right, so welcome to our second class. In this class, we'll be specifically analyzing the differences between civil law and common law. So here you have a global map. Usually, even though there's obviously more than two legal systems on planet Earth, usually they tend more towards the one or towards the other. So you have here in light blue, you have sort of the countries that apply a more civil law-based system, even though they have peculiarities according to their culture. And in red, this is like red pink, you have common law countries, right? So New Zealand, Australia, basically anywhere that was colonized by Britain. Some emphasis here to be given to Quebec, Louisiana, and Scotland. You can see they're in pink. And this is because those places have a lot of civil law influence, in particular in private matters. So here in Louisiana, that used to be a French colony, you have the influence of the Napoleonic Code. In Quebec, also a former French colony. A lot of French is still the official language, a lot of French influence. And Scotland and the UK only became one country together in 1707. So that's also why there's significant differences between the Scottish legal system and the English legal system, particularly in civil matters, not in criminal matters as much. And also, South Africa, I do talk about this. India is a special case because it is perhaps the most different of all the countries that we consider common law countries. I do talk about them a little bit, but usually a lot of people don't even consider them common law, more like they even call it like something else, like Hindu law. And you see a lot of peculiarities. It's actually a legal system that's closer to ours than to the UK's or to the US's. All right. So here I made a little table. This is generic if you think about every single country on Earth, not about our country in particular. And obviously, like I said, there's a convergence, right? So the tendency is that these differences, they begin to vanish more and more, right? So for instance, anywhere you look what are the differences between civil law and common law, they're going to talk about the idea of the judge not being inquisitive and not having an accusatory system. And that used to be true, but it really isn't true anymore. Our country in particular strives to have an accusatory system in criminal procedure, an adversarial system in criminal procedure, and not an accusatory system, right? So, So our country in particular strives to have not a procedure that's presided and mandated by the judge, but where you have parts litigating against each other, right? So it's an adversarial system, not an inquisitorial system, even though most places and most sources will still cite that as a difference between civil law and common law. Today, the trend is for all countries, all democracies, to have an adversarial system in criminal procedure, even though historically that used to be different. So this is the difference that doesn't matter as much. Obviously, the most important thing would be the influence of precedent, which is much greater in common law. This is what people usually tell you is the difference between civil law and common law. I think the difference is broader, and I'll explain that in the next few slides. But basically, precedent is much more important to a common law country than to a civil law country. That's where the idea of stare decisis comes from. So it's binding precedent. Treat like cases alike was another thing that you hear a lot. And here in Brazil, we have since our last constitution started to pay a lot more attention to that. So it's not correct to say that precedent doesn't matter here. And I would say that most civil law countries today have some form of precedent. Obviously, in common law, it is still more important, specifically because, like I said, there's this idea of equity in common law, and the law being this thing that is understandable, that's not based on abstract philosophical ideas, which is why you have a lot of more precedent, because things are decided on a case-by-case basis. There's no one trying to come up with the all-encompassing philosophy for all situations, which is more or less what tends to happen in our system. In fact, it's funny because if you look for any sources to learn about American law, you're not going to find, like in our system, legal scholars writing long books about civil procedure or civil law or criminal law. You're going to find more summarized versions just pointing to which precedent you have to read, because you learn effectively by reading precedent. Which is why it's so important to read precedent, and which is why you have to read the 10 cases that I selected in order to finish the course. All right. Like I said, Louisiana and Scotland a bit more influenced by civil law. Also, many other differences between the United Kingdom and the United States. One being obviously that the United Kingdom is still a monarchy. It still has nobility. It still has peers. And in the United Kingdom, legally, perhaps the most important difference is the absence of a written constitution in the United Kingdom. There's an unwritten constitution, which we'll analyze in class 3. And because of this, there's this idea of parliamentary supremacy. So the British Supreme Court does not have the ability to conduct judicial review, and Parliament usually has the final say in all matters, even though the King still holds a certain ability to block legislation, which he has not used in 300 years, but it still exists. So the idea of parliamentary supremacy is present in countries without a written constitution, which, for our intents and purposes in this course is going to be New Zealand and the United Kingdom. Another interesting difference is the contractual freedom, right? Because common law is more geared towards, the practical matters, case-by-case analysis, there's not a lot of restrictions on contractual freedom. Because in civil law countries, you have this idea of, a philosophical sense of what constitutes a fair contract, and you have more intervention on what can and cannot be in a contract and what clauses a contract can have. But in common law, there's a lot more contractual freedom. So they do allow you to do some things which we would find quite, perhaps sometimes even appalling via a contract. You see this a lot with prenuptial contracts, which you just call a prenup, which is a contract you sign before marriage to determine how the wealth and how the net worth of the couple is going to be administered during the wedding or after the wedding. Like I said, stare decisis and binding precedent. This is very, very important, and it was given even more importance during the Industrial Revolution, because it was a good way to protect trade. Judicial security and judicial stability is important for trade and for capitalism, which is one of the main reasons you see this being developed in every country on earth, because most countries have a capitalist economic system. And in a capitalist system, judicial security is very useful and it's very good. Lawyers, this is also interesting. I think this reflects the system very well. Here, a lawyer goes through extensive philosophical training, right? Anyone who goes to law school here has to read philosophical books. In the United States and the United Kingdom, for a long time, there was the possibility of not even attending law school in order to become a lawyer. So one example is Robert A. Jackson. He was the chief U.S. prosecutor in Nuremberg, and he became a lawyer by just clerking with an established attorney, so working with an established attorney, until he qualified to take the bar, right? So the bar exam in the United States and also in the UK is what you take in order to become a licensed attorney. So law school used to be optional, and I think this ability is still in the books in some states in the US. It's really not done anymore by most people. Pretty much everyone attends law school today, but in the past, it was very common for people not to go to law school or just take a legal conversion course. That's also a possibility. So also a law course, when you get a law degree, it's something you do after you get your undergraduate degree. So you go through 4 years of college, and then you get usually a 3-year degree from a law school, right? So it's very different from what we do here. And when you're in law school, you're more concerned about learning case law, and you're not as concerned with deep and complex philosophical theories as we are here in a civil law system. Trial by jury, because common law is based on this idea of what's equitable and what's fair, in accordance with the common man, the average man, you have a trial by jury, which ensures that. And this is good because in a system that doesn't have these deep philosophical explanations and theories behind the law, a trial by jury ensures that the judge will not act in an arbitrary manner. So if you in order to be convicted criminally in the United States for all crimes and misdemeanors with a sentence longer than 6 months of imprisonment, you have to be convicted by a trial. You can also take a plea deal, but you have a constitutional right to a jury trial. This was established in England with the Magna Carta in 1215, and also in England you have trials by jury for criminal matters. There's some talk about reforming that system today because it is a flawed system. It was very advanced when it was first developed. Today, many people see it as a flaw. We still use it in Brazil for some things, And in the United States and in the United Kingdom, one interesting aspect which is completely absent from our legal reality is the ability to have a trial by jury in a civil case. So if you have a contract dispute and maybe it's really relevant and you're in a federal court, you could possibly have a trial by jury. And that would, of course, be something that is perhaps more legitimate to the average person because it would be decided by a jury of your peers. So it's going to be common people. It's not going to be just lawyers and judges deciding. All right. So like I said, the distinction that matters most is equity and common law. Because when common law is not enough, you step in with equity. You remedy that with equity. So the idea of public and private law is not really present. You're not going to have courts in the United States, for instance, which specialize exclusively in public law. You're going to have courts that you just do all things, right? So in the United States, the only high court that exists is the Supreme Court itself, right? Beneath that, you have district courts for separate districts. Usually a district court in the United States will group up several different states, but it still takes any sort of a case that you might argue in front of it. So criminal matters, public matters, or civil matters. And this is something that's also the case in the UK. So usually they don't have, common law countries tend to not have as many specialized courts as civil law countries. So for instance, in Germany, there are a lot of specialized courts. You have you have one for labor law, you have one for administrative law. So, and the same thing in Brazil, you have specialized courts in our capital. And this is not something that is as strong in common law countries. Right. This is, to me, is the most important distinction between civil law and common law. And this is something you get from people studying law in common law countries, which is they don't really tend to view law as a science. Of course, they're still going to use that term now and then, but we even call our law schools science centers. We view it as a science. And people in common law countries tend not to do that. They view it as a way to mediate conflict and to solve conflict. They don't view it as a science, as something that can be experimented with in the same way we do. So there's not going to be a lot of people doing very elaborate and complicated legal theories to explain things. It's just going to be what the law says. If the law isn't enough, when I say law, I mean written law, statutory law, you step in with, common law courts or eventually equity courts. You're not going to appeal to complex philosophical arguments the same way we do here in Europe and in Latin America as well. You have these very complicated ideas, and you see this in every area of law in Brazil. Which, to us, it's natural, and I think it does help ensure fairness, but it also makes the law very inaccessible. It makes the idea of a decision very inaccessible. This is something that you can tell when you read a decision by the American Supreme Court. You can see that a lot of the arguments they make are either based off precedent, or they're more based off a natural understanding that any average person could have. And not really very complex, legal theories from the 1600s, 1700s, 1800s, which today, if you read any case law from our Supreme Court, you're going to see very old authors and very old books being cited, and that is something that doesn't happen as much in a common law country. They tend to quote more precedent and ideas which are more, in line with, the average person. Which is why it's much easier if you're fluent in English to read a decision by the US Supreme Court than by our own Supreme Court. Here, this is a very recent decision by the Supreme Court of the UK. And you see here, trials are conducted on the basis of the principle of natural justice. So this is something that happens in a jury trial. A juror, when he gives his vote in a jury trial, he does not have to say why he's voting to convict or to acquit the defendant, or why he's voting to give a party in a civil litigation to recognize their right or to not recognize their right. He just does. And he does so more in line with an idea of natural justice. You're not going to see a lawyer in a jury trial, arguing based on very abstract philosophical principles. He's going to try to appeal to the common man in a more accessible manner. And this is something that permeates the entire system, both in the UK and in the US. All right, so this was our second class. Hopefully you have a better understanding of what common law is now. In our next class, we'll go over the British constitutional system. We'll start analyzing the proper law itself. All right, see you then.